Welcome. Good morning for the Americans. Good afternoon for the Europeans. We're just waiting for 2 more minutes for some people that send us messages. They're trying to connect. So let's wait for them to connect, and in 2 more minutes, we start. See you soon. So we are back. So welcome, dear friends, clients, colleagues, partners. I hope that everyone are doing well. It's a pleasure to welcome you all. My name is Mauricio, and I'm one of the partners of the FIUS Advogados. And we are gathered here today for one more webinar, this time focused on the international public. And what happened was that during this crisis, we've been making a huge effort here to assist our clients and companies to sustain their businesses in Brazil through these difficult times. And so we assembled a specialized team to keep track of all the legal changes and to provide valuable insights on how to face this difficult issues, especially in labor law and tax legislations, in contracts, contract regulations, and also corporate and environmental law. And so because of all this, we propose to host this webinar specifically to the international public, so we could provide these insights and comments on the most important aspects on the Brazilian law that companies should be looking at to navigate during this coronavirus crisis here in Brazil. And so as an introduction, I would just like to make some quick remarks regarding our government and the stability of our institutions here in Brazil. And the main message that I would like to convey here is do not believe in whatever you see in the media and the television. Because you see, if you look at what the mainstream media is conveying right now about our government and especially about our president, is a picture of uncertainty and chaos that I can tell you is completely different from the reality. We've been working with the government for years now, and we can assure you that we probably never been as stable as a country as we are today. The way that the executive cabinet was built with members of technical background and not with political background had really made an impact, a difference. And we can assure you that not even the Brazilians in their majority are aware of the size and the relevance of the changes that have been made internally in the government so far. What happens is that we have two main problems here. So at one side, we have an idea that for 16 years was overpowered for the left flag government, and it still has its impacts. And on the other side, we have a president that cannot maintain his mouth shut. And so that's the main problem that we're facing. But what we can tell is that besides all the president's capacity of talking rubbish, technically speaking, he and his cabinet, they are doing an excellent job. So what we can tell is rest assured that, of course, despite all this coronavirus crisis and all these unpredictable circumstances, we are facing here in Brazil a period marked by strong institutions and a pretty solid government. And we tell this because we consider this is very important for the security of our clients' investments here in the country. And so, having said this brief political overview, and moving forward, I'd like to start with the webinar. And so I'd like to ask Bruno to share the presentation. Okay. And so we are going to talk a little bit with you about the legal impacts for business in Brazil of all this coronavirus crisis. And as a start, I will call Bruno Santo, which is one of our fellow lawyers at the office, to talk with you a little bit about the evolution of the coronavirus crisis here in Brazil, and also brief overview of all these legal changes in the regulations that we've been facing here. So Bruno, you have the word.
Thank you, Mauricio. It's a pleasure being here and talking to all of you. Regarding the presentation, our agenda here, as you can see, it establishes the first topic that we're covering. It's just a high-level perspective on how the Brazilian legal framework is working a little bit during this coronavirus crisis. So very recently, in early February, the Brazilian government enacted some measures and declared the outbreak of the disease a national public health emergency. And then a law, federal law, was passed by the Congress that outlined the main aspects of the measures to combat the widespread of the disease in Brazil. And this was pretty early on, since only in late February, we had the first case of COVID-19 confirmed in São Paulo. So our federal government enacted these very broad and very general measures early February. Late February, we had the first confirmation of the disease. And then by mid-March, we had an escalated about 900 confirmed cases and 10 deaths, which forced our Congress to declare a public calamity state. Again, setting forth major guidelines, since in Brazil, our constitutional framework allows that health issues are legislated by both federal, state, and local municipal levels. So the federal government ends up setting forth these general guidelines for social distancing and what should be considered as essential activities and services. And then throughout March, a number of states and local governments passed rules, local rules, imposing social restriction on private activities and restrictions on the freedom of movement. At the end of the day, what we see is that federal legislation, it's not self-executable. You need states and municipal regulations to clearly detail and to clearly set forth what would happen in each city and in each state. And I think as a general rule, that's what we should be looking at. In particular, are these states and municipal regulations, because at the end of the day, they are the ones that would be in charge of of supervising and putting up all the measures on the activities, for example, of your company established in a specific place in Brazil. We should look at the federal legislation, but we should primarily look at the municipal legislation and the state legislation. So this is a very high level perspective of the legal framework and how it works in Brazil. I will pass on here to a quick view on how the Brazilian curve, the disease curve is behaving so far. These are data that we gathered from a site that is All Road in Data, and the source is the European CDC. As you can see here, Brazil has not spiked as much as other countries. Of course, there are reasons for limited testing and so forth, but the data that we have sets Brazil at this lower pace of the evolution of the disease, while we have maybe the United States for a time and Spain and other European countries spreading from every 2 days, the cases doubled. Brazil is at the somewhere near 3 and 3.5, 4 days of confirmed cases. This is not a good slide to look at. I'll pass very quickly, but these are the confirmed deaths. Brazil is also at the stage of maybe 3 days of doubling every day, every 3 days doubling the deaths. And this is a very interesting curve for us to look at, because it highlights a 7-day rolling average of confirmed cases, and it attempts to show a little bit of the countries, are they flattening the curve? As you can see from this data here, Germany, Italy, and France, and the United States, maybe in a few days, are actually flattening the curve. Brazil, not yet, but soon will be. And then this is the data that we all want to see, the countries that are controlling the disease. And I think in Brazil specifically, what we had is that we took measures very early on, because the Brazilian government, seeing what happened throughout the world, could control a little bit more of the disease and the curve. And hopefully that's what we will continue to do. And hopefully, as well, as we are seeing the news today and yesterday, that's what's happening throughout Europe, and in a few days, we hope, in the USA as well. So now, Mauricio, if you want to introduce the next speaker, this part of the framework and the curve. If anyone has questions, I'll be happy to answer afterwards.
Okay, thank you, Bruno. And those of the attendees those of you who have any questions, I will ask you to leave down here at the Q&A, and we will convey them to the speakers at the end, okay? And so now I'll call Melina Simão, and she will talk a little bit about the labor law measures that we are having here, especially aimed at mitigating costs to the companies and assisting companies to preserve their working force. So Melina, you have the word.
Thank you, Mauricio. Well, good morning or good evening. I don't know where you are, so I'm pretty happy to be here today. And before starting talking about how the labor relations were directly affected by COVID-19, I think it's really important to tell you that the rules in Brazil, the labor rules in Brazil, they are very strict. This is because our labor court is too protective. Our labor law is old, it's from 1943. And even after the labor reform that we had now in 2017, the law still protects a lot of the employee because it's the weakest part of the relation. But as we know, the World Health Organization has been reinforcing the need for social distancing to contain the spread of COVID-19. And because of this, economic activity has been feeling the impact of the crisis directly, because many activities are suspended. They are not considered essential depending on the activity, because the districts and the states decided to restrict the sectors that are remaining in operation to avoid the spread of the disease. And in order to minimize the harms to employment and income, which means to help both employers and employees, Brazil introduced some emergency measures. And in view of our strict law, we don't have many measures to renegotiate the conditions of the employment, but we do have alternatives. The government has made efforts to bring in instruments that can be adopted by companies to meet their needs. It's not mandatory, the company can option for that, but regardless of what is adopted, we think that transparency and prior communication to the worker is extremely important. And the provisional measures that I'm going to talk to you were created to minimize the impacts during the public calamity period, which means it's until December 31 of this year. So let's go. First of all, on March 22, we had the provisional measure 927 that was published to suggest some measures not directly that don't directly impact the payroll, but they promote the social isolation, the social distancing. Here arises the possibility of making the work from home a little more flexible. So if the activity can be carried out from home and not necessarily at the company, we extremely recommend that this is done to avoid the crowding and contamination in the work environment. It is also possible to anticipate individual vacation, even if it's from future time, and non-religious holidays. Also, now we have more flexibility on granting collective vacation. And for all these measures, the employer can make the decision on his own and just communicate the employee. But we also think it's really important to mention that and to emphasize that there is a need for transparency and solidarity. It's also possible to use hours in stock at our bank, giving the possibility for the employee to rest now at this moment of crisis, and then later on compensate by working. And this would be about within a year and a half after the end of the public calamity. And finally, an interesting point of this provisional measure 927 is that discussion that mentions that COVID-19 will not be considered an occupational disease. However, if the employee files a lawsuit and can prove to the judge that he was contaminated at the company while he was working, then the company can afford damages, can be convicted by moral and material damages, for instance. Well, furthermore, at the beginning of this month, on April 1st, there was a new provisional measure, that is the 936. And this one came with stronger alternatives to adjust payroll costs. After all, in face of this pandemic, depending on the demand, there is no need to keep the employee working all day. So we can reduce the working hours, or maybe we can avoid that he goes to the company, that this activity remain open. So the government now decided that it's going to contribute with public resources to assist the companies with their needs. So part of the workers' income will be paid by the government as an emergency program. And the investment by the government will be about 53 million reais, which is almost $10 million. It is also estimated that 23 million people will be covered by this measure. And it's required that this employee has a formal contract, does not work for a public company, and is not receiving certain social security benefits. Thus, we have the possibility of reducing working hours and wages in a proportional way by up to 25%, 50%, and 70% for 90 days. But how does this work in practice, Melina? Well, Suppose that the employee has a monthly salary of 2,000 reais, and then we decide to reduce his working hours and his wage in 50%. The company will pay 1,000 reais, which is the reduction of 50%, and the government will assist with the equivalent of 50% of the unemployment insurance, which is about 700 reais. You can see that in your screen. And in total, this employee will receive 1,739 reais and 95 cents, because it's a composition of the money from the company and the government. It is also possible to temporarily suspend the employment contract for 60 days, and this period can be split in 2 periods of 30 days. In this case, there will be no work and no payment of wage, of monthly salary, but some benefits should be maintained, such as the health insurance and food vouchers. Well, to use these measures, in some situations, the company may proceed with an individual agreement, which is from the company directly with the employee himself. And in other situations, the company will have to participate of collective bargaining, which is a negotiation directly with the trade union by collective agreements. However, we have been facing some legal uncertainty nowadays because many people are understanding that this provisional measure 936 is unconstitutional. Recently, a minister of Supreme Court here in Brazil, he's called Lewandowski, he decided that this measure is against our federal constitution, because the constitution that we have in Brazil specifically says that the trade union must be involved when you're discussing the reduction of wage, but which is against what the provisional measure suggests. So this will be a part of a judgment that is going to happen next week on April 16, and we must wait for the decision of the Supreme Court. But our guidance here is that the companies that decide to sign this individual agreement to reduce salary and reduce working hours, they inform the trade union that they're doing with these terms, and then if nothing is said in a deadline that is stipulated for the union to respond, then you can assume that your agreement is valid. But what we think is that it's necessary to create some evidence to show in the future, if it's necessary, that you actually communicated the union. So it's really important to send telegrams to the union with an acknowledgement of receipt. I believe that the intention here today is that we make stronger our bonds of solidarity, so that companies and workers get out of this crisis stronger and in the best way as possible. Therefore, it is up to you to adopt the action plan that best fits your needs. I must say that there are no best, there doesn't exist a best rule, a best plan of action for all of us. We need to analyze what are the needs of the company. So everything will depend on the reality of your business and the cash flow of each single company. And finally, I believe it's worth saying how the labor card has been dealing with COVID-19. So here in Brazil, the labor card suspended deadlines and hearings until the end of this month, but it's pretty possible that this get extended considering the pandemic. However, the card remains active because it's rendering decisions daily. And we also believe that this moment, besides this delicate, we think it's an important moment to start to think the possibility of settling in strategic labor cases. We think it's a good moment for try to negotiate. So we have materials with detailed information of what I mentioned here, because I must say that there are a lot of rules and deadlines and important details. We will be very happy to share this material with you. And if you have any doubt, contact us. We have the email from the office. We'll be very glad to help you in this situation. Please stay home if you can, stay safe, and thank you so much for the opportunity.
Great, Melina. And there's a question for you here. There's a question if whether these measures are in fact avoiding unemployment. Do you have any comments on this?
I believe that it's delicate, this thing, but I believe the government decided to publish these measures specifically to avoid unemployment, because both employers and employees are facing difficulties with this crisis. So despite we all not maybe agree with these measures, we believe that it's a possibility to contain the employment and contain the wage, at least for this specific moment of crisis. So both employers and employees get out of the situation in the best way. Of course, we have a reduction of wage, which is not a good thing for the employee, definitely, but maybe it's best than to lose the job. As we have been seeing, some companies are closing, some companies are simply dismissing a lot of employees. And we believe that this situation that the government now created might help in the situation.
Okay. Okay, thank you, Melina. And so moving forward, we will be back to Bruno. And he now will have the tough challenge to talk a little bit about effective ways on how to manage taxes in Brazil during all this crisis. So Bruno, what do you have to say about it?
Thank you, Mauricio. Of course, it's usually, I mean, under normal circumstances it's not easy to discuss taxes in Brazil under normal circumstances. And especially now that we are dealing with this very extreme and unusual circumstance. But what we need to say is that there are important measures that are already in force in Brazil that are aimed to basically protect cash flows from companies, because they tend to delay or to reduce some tax burdens. Of course, on the other hand, the Brazilian government relies on tax revenue to cope with all these programs and to be able to put programs that keep that are aimed to maintaining jobs and so forth, and keep the economy as well running. So, but looking at the companies, we do have some very interesting issues that we would like to talk about. The first one, and the one that might be the most effective for cash flows in Brazil are the reductions, actually the delayment in payments for the PIS and COFINS. For all of you that are not familiar with Brazilian tax laws, PIS and COFINS is a social contribution that's levied over total revenue. So it's something that if the company sells products or sells services, it has to pay on the total revenue, not on profit. So it really affects cash flows. And other taxes that were delayed, the payments were delayed and postponed, were the federal contributions on payroll, which are called CPP and CPRB, for you that are familiar with that. So this is basically payroll taxes. March and April, these contributions that were due on March and April have been delayed to August and October. So this is a very interesting cash flow, positive cash flow that will be generated for the company. Another kind of payroll tax is what we know as the S system, which is contributions on payroll as well, aimed to finance several assistance programs in Brazil. And this one, we had an actual reduction of 50%, and there are several rates, and they were all reduced by 50%. It's an interesting issue to look at as well. The FGTS, which is the Social Severance Fund, which is 8% on payroll, was also postponed. Payment was postponed for 3 months. So companies will be allowed to start paying these 3 months from March to May, beginning in June this year. So it's kind of an installment program with a delayment, a postponement in payment. A very, very interesting thing is that Brazil has this financial transaction tax, which is called IOF. And this tax is usually due at 0.38% plus an additional rate depending on the maturity date of loans, local financing. It was reduced to 0. So intercompany loans, if companies need to move cash around in more complex groups, it's an interesting way to move cash around, maybe to look at loans. And also local financing was reduced. This tax was reduced to 0. And we have an excise tax, which is called IPI, and an import tax that they had rates reduced to 0 as well for many products that help to combat and to avoid the spread of the disease, alcohol and so forth. We had some loosening on the rules, on the bureaucratic rules for imports and foreign trade operations in certain specific case. For instance, Brazil has this electronic system, but you needed to input documents physically sometimes when you imported goods from abroad. And now you're able to do that electronically, which is under the Syscomex system. And also we had it's a little bit easier for companies to get customs clearances in certain circumstances here in Brazil. For instance, the companies that are authorized economic operators for foreign trade, they can speed up a little bit the customs clearance. We had a waiver of tax clearances, so whichever company that had a tax clearance certificate, that would remain valid for further 90 days without any additional action needed from the company. So these are the measures that are already in force. Of course, this is a high-level view on those measures. And now I will get into a little details of what tax lawyers here in Brazil are discussing with multinational companies regarding tax strategies that we should feel everyone should be looking at. Of course, tax governance was always on the top of the agenda here in Brazil, but now more than any time, it's necessary to reevaluate the tax planning, to reevaluate how cash pooling and cash management around the whole group is done. Looking at the IOF, which is the financial transactions tax, now it's reduced to 0. And maybe looking at, for multinational companies, if you're planning to inject capital in Brazil, there are some taxes that are levied there. If you are planning to get money from Brazil and to use that cash that's sitting in Brazil to fund other operations in other countries, we'll be looking at dividends, at royalties, and payments for services. All of these inflows and outflows of money from Brazil, they have different tax impacts. So it's a good idea to reevaluate them, since some of them, like payment of services for a foreign entity, could end up generating a 50% tax cost in Brazil sometimes. That's what we think that everyone should be looking at as well. Brazil has several taxes that are VAT style taxes, which means that you can recognize tax credits from purchases and from expenses that the company has, and you need to pay them, net them on the revenue. So it's levied over the revenue as well, and you pay the net from the debts that's levied of the revenue and from the tax credits that you get from purchases. And there is several discussions on what generates a tax credit from the purchases, what doesn't, and we should always reevaluate these criteria. Our Federal Superior Court of Justice has just recently, about a year ago, changed a little bit the understanding on the PIS and COFINS credits. It loosened a little bit and it made it a little bit broader for companies to look at what expenses can generate tax credits for PIS and COFINS. It's an interesting thing to reduce the tax burden. Of course, corporate income tax, as you noted from the previous slide, is not under any type of postponement or delayment. So companies that are in a profit-making position here in Brazil would and should be looking at how to reduce corporate income tax. And then there are several things that we would need to evaluate. The add backs. Brazil works much like the other countries that we have the accounting income being taxed after we had add-backs and exclusions from the taxable basis. Of course, in Brazil, we have a heavy load of payroll taxes. It's a good time to re-examine what kind of payments made to employees should or should not be taxed for these payroll taxes. We have several discussions on this as well. We can't forget tax compliance, and sometimes if you're not compliant with tax filings and ancillary obligations, there are heavy fines. Some of the tax filings were also postponed, which is the EFD and the CTF, which are federal tax filings, basically for PIS and COFINS and for other federal taxes. They have been postponed, but not all tax filings have been postponed, so that should be looked at carefully as well. We have a number of interesting installment programs, both at the federal and the state level. You can maybe have a dilution of your cash that will be used to pay tax if you enroll in one of these installment programs. We do not have yet a special program for this crisis. It may be underway, but we have several normal and usual programs that companies can use. And also, if cash becomes very critical in Brazil, we have a number of clients that are attempting to file lawsuits under the argument that you can postpone every federal tax for 3 months, which is something that has been debated in Brazil, but there are very favorable arguments in this way, and it's based on an ordinance from the Ministry of Finance back from 2012 when we had a previous crisis, a local crisis, another type of crisis, and the Ministry of Finance allowed postponing all federal taxes. Like I said, today, at this moment, from the law that's in force, you cannot postpone all tax payments, only the ones I mentioned before, which are PIS and COFINS and the payroll taxes. But through a lawsuit, you can you can attempt to postpone every federal tax payment for 3 months as well. So basically, that's a very broad overview on how to manage taxes in Brazil. I will be glad to answer questions that you have as well. I don't know if there are any questions.
There's a question here for you, Bruno, regarding this postponement of the payment of taxes. The thing is, the question is whether postponing the payments for 3 months, does that mean that in 3 months, the company will have to pay all the late funds from the previous 3 months and catch up on all the payments from then on? How does that work?
Actually, how it works, when we look at PIS and COFINS, and when we look at the payroll taxes, all of the months will be due on August and October without any fines or interest, okay? When we look at this federal severance fund, the FGTS, as from June, you'll be able to pay that in 6 installments. So it's not exactly a one-shot payment for PIS and COFINS and for payroll taxes. They will be due on August, and then on October, alongside with the other months. So, but the FGTS, the severance payment fund, that will be made in 6 installments during June, as from June forward.
Okay, and before moving forward, we have some questions for Melina regarding labor law. And the first one is regarding those reduction of wages. How does that work, the reduction of wages and the work time? If you reduce the wage like 50%, does the workforce continue with the normal 8 hours of work? How does that work? That's the question.
Yes, so it's in a proportional way. So if you reduce the wage, you also reduce the working hours in the same percentage. So if you have a reduction of 50% of the wage, you also reduce your working hours in half. For instance, if you work 8 hours a day and you will only work for 4 hours.
Okay, and another question that they made for you is how do you compare the measures that have been taken in Brazil regarding labor law with the measures that other countries, other development countries are taking? Are those feet with the other measures that we've been seeing all over the world?
Yeah, I think Brazil is always a little different because, as I mentioned, our labor rule is very strict. So we can have many different measures compared to the other countries. So here in Brazil, we had to take the necessity in accordance with our law here. And since our law is old and is strict and the labor code is too protective, maybe we can see some differences between Brazil and the other countries.
Okay, thank you, Melina. And so moving forward, now I will call Talita and Marina. We are facing some extraordinary and predictable circumstances here. And those circumstances hit the companies so hard that many companies are finding it difficult to enforce contracts or to fulfill their contractual obligations. So I will call Talita and Marina to talk a little bit with you about what to do with contractual obligations. So please, girls, you have the word.
Hi, Mauricio. Thank you. Hello, everybody. And thank you for this opportunity. I'd like to also thank all the viewers for spending some time here with us to discuss all this matter here in Brazil. Of course, COVID-19 has impacted us all personally and professionally. And this means that in the life of the company, the contracts will be affected as well. And the first question that we hear is, can COVID-19 justify a claim to release a party from a contractual obligation? Of course, the pandemic is an unforeseen event regarding the contracts that were formalized before its occurrence, but it does not affect all the agreements the same way. And this is important because each contract is unique and demands a case-by-case analysis. For example, on food and medical industry, for food and medical industry, the pandemic has affected in a way that the sales are increased because these are basic needs. So we have to analyze each case and each contract and each obligation due to coronavirus. So to analyze the impacts of the event of the COVID-19 on the contract, there are some strategic issues that we need to look at, and this is what we propose. The first issue that we need to address is what a specific agreement establishes regarding force majeure risks. This is because sometimes the agreement sets for a number of obligations and procedures that should be taken by the parties when they are facing some fact that prevents them from fulfilling an obligation. After, the other issue is, which are the effects of COVID-19 pandemic on such agreements? Because as I mentioned before, the pandemic affects each contract and each obligation in a specific way. So we need to look at this specific obligation, this specific contract. And after, have those effects compromise contract performance? If so, in which extension? For example, a measure issued by the government could have directly affected contract performance or just impacted it in an indirect manner. In the case of stores, for example, they are not allowed to open and receive their clients. Therefore, COVID-19 has a direct impact. However, regarding the indirect impacts of the economic, for example, so this is an indirect that is affecting us all. So, of course, this is not a reason why you need to release yourself from this contractual obligation by it means. After, if we analyze this, there is an effect, and this is a negative effect of the possibility of a party to fulfill its obligation. The next issue we need to address is, are those effects permanent, making it impossible for the obligation to be fulfilled later? Or are those effects temporary and make it possible and useful for the obligation to be fulfilled later? Because in the first scenario, we will discuss a termination of the contract. And in the second scenario, we will discuss the suspension of the contract as long as the effects are preventing the party to fulfill its obligation. And the important thing that I need to address to you here in Brazil is that the scenario is that sadly, sometimes COVID-19 has been used as a general reason to justify a claim or an intention of a party to release itself from fulfilling an obligation. But it should depend on the case-by-case analysis and the risk allocation on the terms and specific agreements. And this is an aspect that our judges are looking at right now, because we need to point out that these effects prevents a party from fulfilling the obligation, and not generally say that COVID-19 has impacted and therefore I am releasing myself from the obligation. So once we have made this analysis, we should look for the theories here in Brazil that deals with unforeseen events regarding contracts. The first theory I'd like to address with you is the force majeure act or act of God. The force majeure and act of God theory is predicted by established on our civil code. And by definition, we have to fulfill 3 requirements to use this theory. The first requirement is we have to be dealing with a supervening event, which means this event should have happened after the agreement was signed. The second requirement is it should not be attributable to the debtor. Therefore, if I say that this act has happened, it should not be linked to an action of me to have this have happened. The third requirement is party could not have avoided its occurrence and its effects, of course. And this is the case of the pandemic. Of course, nobody could have foreseen it and nobody could have avoided its effects. So, of course, once we have these requirements fulfilled, there needs to be proven a causal connection between the event and the effects of the impossibility to fulfill the obligation. As I mentioned before, it's a case-by-case analysis, so we need to look at the specific obligation on the specific contract. The force majeure is provided, as I mentioned before, by the Brazilian law. However, parties can expressly exclude the application of force majeure provisions in each contract. For example, which means a party can be liable for unforeseen events, but of course, this is rare. An example that I can give you is, for example, constructions. Sometimes constructions, we have on the agreement that when a rain happens above a number of millimeters, that will not be considered as a force majeure event for that contract specifically. Because party also knows that the rains in that specific millimeters is expected on that time of the year. This thing regarding the force majeure provided by Brazilian law is important to point out, because we know that in other countries, the force majeure has to be set for on the agreement in order to be possible for a party to be released itself from the contract obligation. However, here in Brazil, this right is provided by the law, which means that if the agreement refrains from providing about force majeure, the party can still claim force majeure, because this is a right that is predicted by the law. Okay, so once we have fulfilled all these requirements and we can prove the causal connection between the force majeure and the impossibility to fulfill the obligation, we have to analyze, because force majeure gives rise to the termination of the contract without penalties, or the temporary suspension of the obligation without penalties. And this depends of, as I mentioned before, if this impossibility to fulfill the obligation is permanent, which will lead to the termination, or if it is temporary, and in this case we are dealing with a suspension. Which means, of course, and I don't like to repeat myself, but this is important, it's a case-by-case analysis, and we should not use COVID-19 as a general reason to release it, to file a claim to release ourselves from a contractual obligation. And for the next theory, I would like to ask my colleague, Marina Rossiti, to present it to you. I will be at your disposal alongside with Marina to ask any questions you have. Thank you.
Thank you, Thalita. Good morning. My name is Marina. I am a lawyer in the contractual department of the law firm Pinocchio Justra, alongside Thalita. Thank you for listening to us now and to talking with us about the legal effects of the coronavirus pandemic. So I will address now the second theory we want to explain to you. That's the so-called excessive onerosity theory, or the fundamental change of circumstances. This theory is only applicable to long-term contracts because we have to see a fundamental change of circumstances. So we have to compare how was the situation when the contract was closed and how is the situation now. So short-term contracts cannot have this comparison. So this kind of theory is only applicable to long-term contracts. And we have to verify if there was a fundamental change of circumstances. That means that a disbalance between both obligations happened. That's very important so that this theory may be applied. But what are the requirements for this theory? The first requirement is that we have a supervening, extraordinary, and unpredictable event. That's the case of the coronavirus pandemic. It was unpredictable, as my colleague Thalita already explained, every one of us explained. And it's a supervening. When the parties closed the deal, they couldn't see that this kind of pandemic would happen, and it is extraordinary. It's the first time that it happens. And then we should have an excessively burdensome for one party, and on the other side, an extreme advantage for the other party. To prove this kind of burdensome for one party is not enough, because we have to have this unbalance between obligations. To give you an example, if we import a product from China and the harbors in China are closed due to government restrictions, we have a burdensome for the commercial partner that should import this product. But it's not automatic that the other party, the other commercial party, has an advantage of not sending the product to Brazil, for example. So it has to show this imbalance between parties. If in the case-by-case analysis, we have a fundamental change of circumstances, then there are two possibilities. We can either reveal the contract in order to reestablish this balance, or terminate the agreement if the obligation, for example, is not possible to fulfill. Bruno, could you please change to this next slide? Thank you. So this is the general idea of this theory, of both theories, of the force majeure theory and of the extreme onerosity theory. But we do not intend to sell out the two theories explained above. We only want to bring you general thoughts on these both theories and how they are applicable, but in your day-to-day dealing with your clients, because many clients are saying they are experiencing force majeure or extreme onerosity in order not to fulfill their obligations in the agreements. But at last, but not at least, I would like to bring you some general recommendations so that you can use them on your dealing with the coronavirus pandemic and your commercial clients. The first recommendation I would like to give you is making a detailed revision on existing contracts in order to gauge impacts and outcomes of the COVID-19. In this way, you can prevent from having more consequences than we are already experiencing along with the economic crisis that we are experiencing now in the whole world. The second recommendation would be the so-called meeting of the minds. That is a collaboration between parties towards the effects of the coronavirus pandemic. And this kind of collaboration, collaborative behavior will be valued by our Brazilian judges, because they will take in consideration all the mitigating measures that are taken by clients in good faith. So if a problem is going to be soluted before a court, be decided by a judge, the judge will compare and see if the parties have tried to collaborate and to find solutions in order to establish and to keep fulfilling their obligations. So another recommendation would be to avoid the litigation and try to achieve a consensual solution to the problem, because it's uncertain how the judges will rule the disputes arising from the COVID-19 pandemic. And since there are few cases that were decided, we cannot see how they will decide. So it's important for you to now sit with your clients and your commercial partners and try to find a solution, being very collaborative. And mainly because we will have a post-crisis period. We will survive this crisis, we will survive this pandemic, the contracts will survive this pandemic. So it's extremely recommendable to avoid any conflicts now that may undermine a minimum level of future and necessary cooperation between both parties. So it's also very important to formalize everything in writing, all communications exchanged by you, because this will be proof if the contract is going to be decided by a judge after all. So you can prove that you try to collaborate, you try to mitigate the risks, and you're doing your best part so that the obligation is fulfilled. And to discuss and establish the possible impacts and consequences due to the coronavirus when formalizing new agreements. So we have to see the situation of the agreements that are already closed. So how are we going to fulfill the obligations we already have? But at the same time, if we are concluding new agreements, how are these impacts that we are experiencing now going to impact my contract in the future? And having these thoughts will help us all to find solutions now for problems that may arise in the future. But if you have any questions, I remain at your disposal, Thalita, as well. Please contact us, and I will pass now on to my colleague of the corporate law team. Thank you very much.
Actually, there's already a question here. They're asking if lawyers in Brazil are already considering redrafting the contracts, specifically the clause regarding the force majeure, considering all this chaotic scenario, or is it just this exactly the scenario that these clauses are forged for? Is there any discussion about this already or not? Of redrafting these clauses?
Do you want to answer, Talita, or shall I? Yes, we are already discussing. I've seen many agreements that have already changed their force majeure clause in order to comprise and to include pandemics. But because we have a legal disposition in the civil code, the Brazilian civil code, if the clauses are not amended for the future, it won't be a problem because we'll have the support of the legal of the law. So, but even though both parties, both commercial parties are trying to find solutions and to amend and adapt their clauses in order to foresee and as to how they are going to solve a problem if in another pandemic like this one may happen. So, yes.
Just to complement Marina, this is also a big discussion for M&A contracts on the corporate side. This is already a usual clause for M&As. The provision of something systemic that would affect worldwide is a clause that we usually have in the agreements, but they are now being tested, put to test, a clause that everyone thought, okay, this is just, it's never going to be used. It's an eventuality. Of course, we put it in the agreements, but it was something no one took another look at them. It was just standard to have it. And now we are seeing it being discussed. So it's very interesting in this sense.
There's a question here from Atlanta, USA. And they're asking about what are the best strategies for protecting or changing the contracts of Brazilian investors in the USA? And what do you think about the behavior of American companies? Do you have any comments on that?
Sorry, Mauricio, could you repeat, please?
What would be the best strategies for protecting or changing the contracts of Brazilian investors in USA? I don't know. I think the question is regarding probably the clauses force majeure in the American contracts, probably.
Yeah. What we need to, it's important to address, and I don't know if I can give a general recommendation, but it's important to analyze the specific contract in order to decide how can we handle the situation on the contract. Because sometimes the COVID will not have an impact on the obligations, but sometimes it will, or sometimes it don't, but we will have to establish a procedure on the contract when if we deal with a situation that this in some way prevents a party to fulfill an obligation. So what I recommend is that we analyze the case specific and analyze the obligation to see if there is a necessity to have a specific provision regarding this matter, or if it's not necessary in this specific case.
And to answer also the question of Ezra's, hi to Atlanta, a general recommendation could be that you talk to the Brazilian investors in the USA, because as well as Brazil is facing this pandemic, USA is facing this pandemic, it's a global pandemic. So we have to we have to try to be collaborative, with collaboration to find solutions that may be applicable to this, to the contract, to the concrete case. So our recommendation would be to try to negotiate with your partners, to explain your situation. They will explain their situation. So together you will try to find this balance to recover this unbalance, the balance that is imbalanced due to the coronavirus.
Okay, and so moving forward, I would like to call now Andrea Tincani, and she will talk a little bit about the provisional measure 931 and its impacts on corporate deadlines and registries. So Andrea, you have the word.
Thank you, Mauricio, and good morning, everyone. Thanks for participating today. I'm also very happy to be here, as are all my coworkers. We are now going to talk, as Mauricio said, a little bit about corporate deadlines and registries, and the MP Provisional Measure 931 that brought forward some changes for this period of crisis, and even tried to include a change that would not just be for this period, but we're going to discuss that as well. This provisional measure, it's effective since March the 30th. And one of the provisions that it brings forward is that in 2020, the legal entities that have their corporate year end between December 31st and March 31st will have 7 months from corporate year end to hold their annual general meeting instead of the usual 4 months that they have. So basically they did this to prevent that the companies would have presential meetings in this time of the pandemic. So they extended the deadline that for most companies would end now in April. It's extended until June. So any contractual clauses that require such meetings to be held in shorter periods and were provided in the bylaws or articles of associations are also going to be considered void during the pandemic. They also provided that any terms of office that would end during the period of the pandemic are going to be extended until the annual general meeting is held, or in cases where you have a board of directors until the meeting of the board of directors is held. So for an example, as I mentioned, the companies that had the corporate year end on December 31st, they will have until June 31st to discuss and approve their financial statements, elect officers, and members of the Fiscal Council and statutory committees. This measure also changed the deadline for the retroactive effect of corporate registry. Usually here in Brazil, the corporate acts, they need to be filed before the competent trade board within 30 days from their execution to have effects before third parties since their correspondent execution. As some board of trades have their operation restricted due to COVID-19, for acts executed from February 16 onwards, the 30-day deadline that was already provided in the law to file the corporate act for registry before the trade board, it will be counted from the day when the Board of Trade resumes its usual operations. Also, it's important to note that MP 931 did not provide the extension of the deadline of the Civil Code related to the registry of limited liability company shareholders meeting, which is 20 days. So we don't know how that's going to be treated so far, but probably also going to be extended because, as Thalita mentioned, this is considered force majeure. You cannot obligate someone to meet during this crisis. So the São Paulo Trade Board has suspended, now specifically talking about São Paulo, has suspended its face-to-face services until April the 30th. And most of its services are not yet available online, which is a shame. We are one of the states that is later in adopting the online services. So basically, it's receiving only electronic filing of incorporation acts of individual businessmen, limited liability companies, EIRELI, and doing other non-complex services. The trade boards of Rio de Janeiro, Minas Gerais, Espírito Santo, and Rio Grande do Sul have most of their services available online, but are operating in reduced capability. Also, some corporate acts, like changes of addresses, branch opening, and others, they require the previous approval of the municipality because of zoning restrictions. And most municipalities are operating at reduced capabilities, and some are not even open, have this service open. So this all means a delay in registries, which sometimes can impact, including some fiscal planning, because it delays the change of address, and therefore the change, you cannot issue a fiscal invoice in the new address that you'd have for your fiscal planning. So we are working now, we are trying to find a way to have this change without the registry of the trade board, but this is not usual, it's not how it's usually done. So we are facing some difficulties that we're trying to overcome. Also speaking about registries in Brazil, I just wanted to note that as a rule, they are generally open, they are operating, but at reduced capability. Most notary offices currently require an appointment, and regarding notices, they are either not delivering it, granting themselves a 10 business days deadline to do the notice, to deliver the extrajudicial notices after the quarantine is over, or some are doing it, but with a reduced capacity and taking very long to deliver notices. So this is also being impacted. Another change brought forward by the provisional measure was the possibility of online participation of shareholders in meetings. Before this provisional measure, this was a possibility only for publicly traded corporations as regulated by our Securities Commission. For them, the only difference now is that the Securities Commission may authorize the meetings to be held outside of the headquarters municipality and even to be taken to be held fully online without a local presence. This is only for publicly traded companies. For limited liability companies, non-publicly traded corporations and cooperatives, the possibility to have an online participation of shareholders in a meeting is something new and needs to be regulated by our Department of Business Registration and Integration. This is something that has not happened yet. And this has not happened yet because the regulation of this article is complicated, because the system needs to ensure, the online participation system needs to ensure that the shareholders are appropriately identified, can participate and vote remotely in real time in a way that can be recorded and registered before the Board of Trades. And also as I mentioned, some of our boards still require face-to-face services to register the acts and require us to present the corporate documents in paper. So we would need these documents to be executed, physically executed, to be registered. This is the case of the Trade Board of São Paulo. So they would need somehow to also address this issue. And as well, in spite of being able to offer to the shareholder the possibility of participating online, the provisional measure wording places it as an option and not an obligation for the shareholder. So unless otherwise regulated by the Department of Business Registration and Integration, the company should be prepared to receive shareholders who wish to attend the meeting in person. This is also another problem. The online participation was intended to be a long-lasting measure by the provisional measure. But our Congress is tending to keep it limited for the current pandemic period. We do not have the final vote yet, but we are seeing the trend that they will not keep it as an official amendment to our civil code and the corporation law, but they're going to restrict it to only the period of the pandemic, which is a shame because I think it would be much easier for all shareholders to have this option to participate online. As I said, it wouldn't have to be an obligation, but it would be an option. Also, as I mentioned, all provisional measures, they need to be approved by our Congress within 60 days, counted from the day of their publication, which can be extendable for another 60 days. After the end of this period, the text becomes void if it's not voted by the National Congress, and the effects during the period that it was valid needs to be modulated by the National Congress. So we have this uncertainty. We are keeping a close watch on the actions taken regarding these aspects and are going to keep everyone updated. This provisional measure also includes exclusive provisions for corporations. For instance, Article 204 of the Corporation Law provides that to declare interim dividends, corporation needs to have this authorization in their bylaws. However, the provisional measure 931 authorized until the annual meeting is held of this year, 2020, that corporation's board of directors, if in place, or executive boards, if they don't have a board of directors, can declare interim dividends regardless of provision in their bylaws. This is, once again, to prevent that a general meeting is held without necessity. Also, except if otherwise expressively provided in the bylaws, if they're prevented to do so, corporation board of directors may resolve urgent matters that usually need to be approved in a shareholders meeting. So basically they can surpass their authority and take decisions that would need to be approved by the shareholders according to the provisional measure. But these decisions, they are going to be interim and they're going to have to be validated by the shareholders once the pandemic is over. This is a provision that grants a lot of maneuver space for directors that may decide matters above their authority, but it also brings a scenario of uncertainty for the directors because the decisions need to be later approved by the shareholders. Now going for publicly traded companies, the Brazilian Securities Commission was authorized to extend any terms provided in the corporation law for this period during the coronavirus. And it has already done so for some in the Liberation 849 of March 31st. And it extended some deadlines for documents and informations that need to be periodically provided, such as financial statements, prospectus, registration forms, and reports related to the Brazilian Code of Corporate Governance. Basically, what I did here was a brief summary of the corporate changes that we have with the provisional measure and the regulation of CVM later. Our Securities Commission is called CVM for those who don't know. And me and my team are available if you have any specific doubts or if you have questions now, I'm here. Thank you very much.
Thank you, Andrea. And we have more of a general question here, but I think I can address it to you, which is, what do you think is going to happen with the pending litigations? Because Brazilian courts are well known as slow under normal circumstances. And so the question is, are going to be any delays in the processes? Are there any formal postponements of deadlines? Do you have any comments on this?
Yeah, actually, I was talking yesterday with our litigation team, and what they said is that actually our judges, as the deadlines for the lawyers to present their cases and fulfill their judicial deadlines are suspended, the judges are taking this time to grant older decisions. So a lot of decisions are being made by judges at this point. They're actually using the time to take out the delay. They are working from home and they are actually issuing a lot of decisions. So hopefully there won't be a big backlog. Of course, if law firms stop working and they're not, because basically what they're doing, our team here from litigation, they're still doing the deadlines as if they were running for the process that are online. So that we don't have a backlog. Because if we don't do that, once the deadline suspension is lifted, you're going to have many processes to attend to. So they're continue to work. But what I thought was very interesting was that judges are still deciding.
And in some cases, in special cases, some hearings or audiences are taken online. But that's an exception. I've seen only 2 or 3 that judges that made hearings online, but yeah, so that's a possibility as well.
I think this is going to be a learning, it's a learning opportunity for everyone. And if we can look at the positive side and take a positive view on everything, we are going to come out of this better. So basically, I think this is what everyone is trying to do, and therefore bending sometimes the rule to have an online hearing and to work from home and so on.
Well, there's one more question for Melina, and the labor law subject is fiery today. And it's another question from regarding the reduction of wage. When it says it will last for 90 days, what does it mean? It means it will start on April, May, and from then on, or it's 90 days counting from when the company decides to implement it?
Well, so yeah, the provisional measure isn't that clear. For instance, when we're talking about suspension of the contract, they say that the period can be split in 2 periods of 30 days because it's 60, and then you can split. But considering the reduction of working hours and wage, the provisional measure isn't that specific. But what we know is that the employer can settle this, can do this agreement with the employee, depending on the reduction or maybe the collective bargaining, considering the period until 90 days. So you can start by now saying that it's from April, May, and June, or maybe you can, if the employers see that there is no need to keep it like this, but maybe postpone it, we believe that he can do another agreement to update the decision, to update the deadline. It would depend on the demand. So it can be 90 days directly, or maybe he can change the terms of the agreement.
And what about the percentage of the reduction? Can the employer decide like different rates? For example, all the 3 months have to have the same reduction, or the first month can have like a 70% reduction, and the second month like a 25% reduction, and so on?
Yeah, the provisional measure isn't clear about that too, but we believe that everything can be negotiated, and then you can follow the terms that you negotiate. I believe that the general rule would be to maintain the percentage, but as the provisional measure isn't that clear, I think that you can negotiate with the employee or depending with the trade union, considering the percentage of the reduction.
Okay, so thank you, Andrea. Thank you all for all the information. And I think we are reaching the end of this presentation. So basically what I would like to say, I hope you all enjoyed the event and you found all this information useful. I already shared my email here at the comments. So if any of the attendees have any further questions, you can forward this to the email. We'll be glad to answer. And I will also share a link to our page, the company page at the LinkedIn. There you can find many ebooks with information in English for companies that can guide you through all this process and give you many insights on how things are done here in Brazil. So thank you all for the attendance. Thank you all the panelists for the wonderful presentations, and hope to get in touch with all of you soon enough. So bye-bye, guys.
Thank you so much.
Just to complement, I think if I may, my recommendation would be that to use this period strategically and try to bring forward the most positive things that you can from now. If you cannot work, try to think about your strategy from when we come out of this and try to think positively. We at our law firm, even with the suspension of the judicial deadlines, we are using this strategically and keep working and trying to bring the best for our clients. And I think this is it's general for everyone. So to keep positive thinking and to think about the period that's going to come after this is over. So basically, just to end on a positive note. Thank you, everyone. Thank you, Mauricio.
Thank you.
It's amazing. Thank you, Andrea. Thank you, Bo. Thank you, girls.
Thank you.
Thank you, guys. Thank you, everyone. Bye-bye.
Bye-bye.
Bye. Thank you.